So as you know, in 2011, Texas formulated a voter ID law, which was subsequently overturned by a panel of judges in 2012, striking it down and preventing it from implementation as a function of Section 4 of the Voting Rights. In 2013, the Supreme Court struck down Section 4 of the Voting Rights Act, and Texas began to implement the law which that panel of judges in Washington, D.C. in 2012 found to impose strict, unforgiving burdens on the poor. Now, subsequent to the implementation of that law, the Justice Department sued Texas over its voter ID requirements under Section 2 of the Voting Rights Act, which bans discriminatory voting practices nationwide, but can essentially be enforced after a law has gone into effect. In other words, Texas was under the Section 4 regime, needed pre-clearance from the Justice Department to enact new voting laws. This panel of judges found that it did not meet pre-clearance qualifications. The Supreme Court struck down the statute that said Texas needs pre-clearance. The Department of Justice, after Texas then went ahead and implemented its law, sued them under a different section of the Voting Rights Act. And as part of discovery, they sought to get emails sent amongst Texas legislators to see if the intent was discriminatory. In developing this law, a U.S. district judge has issued an order that directs the state of Texas to turn over these communications about the bills to the U.S. plaintiffs, to do so on a confidential basis by Tuesday, today. According to Texas, 189 state legislators had asserted a legislative privilege over the documents. The judge wrote, the motive and intent of the state legislator when enacted SB 14 is the crux of this Voting Rights Act case. The court finds that overall the balance of factors weighs in favor of disclosure on a confidential basis. The Department of Justice will still have to argue the admissibility of these emails if they're found to have some type of discriminatory intent. But this is important because we will get a sense of whether or not these Republicans in the House planned this to disenfranchise any voters. In other words, as Louis Gohmert would say, we judge by the fruits, not in this case. We're going to look at the recipe that developed the fruits.